Hello students, today we're looking at Unit 2, which focuses on the background to law in South Africa, specifically the court systems and the judicial processes.
Alright, so we'll first look at the Constitution. In terms of Section 165(1) of the Constitution, the judicial authority vests in the courts, and these courts are only subject to the Constitution. Every person has a right to seek relief from a competent court. This is determined by the jurisdiction of that specific court.
So, what does jurisdiction mean? Jurisdiction means the power and authority a court has to hear a matter and to pass judgment in cases brought before it. It entails whether a court can actually hear the matter at all, and that is greatly determined by whether it is a civil case or a criminal case, or in some instances it could be both as well.
This is an important part in terms of understanding, especially for your test 1. You'll be given scenarios, and based on the scenario, you need to then advise the person in terms of which court to go to. Alright, so let's focus in on jurisdiction. So all courts have specific jurisdiction, and you're going to see that South African courts are established hierarchically, from the highest court to the lowest court. The jurisdiction of the court determines its place in this legal hierarchy. Jurisdiction also refers to the limits or orders that that specific court can have and what decisions that court can make. And you'll see this as we go into the specific courts. So not every court, for example, can impose a life sentence, but you'll see this just now. Then we look at another term. It's called exclusive jurisdiction. This is when a specific court is the only court that can hear that specific matter. You'll see, for example, for certain matters, only certain courts can hear those cases. And then we have inherent jurisdiction. It means that this court is a court of first instance and can regulate its own authority and its own power. A court like that is the High Court, for example, but when we get there, we'll explain that in detail.
So, the South African, the judiciary services, the South African court system is organized hierarchically. And what this term means is that the court system is based from highest court to the lowest court, right? So basically, your highest court is going to be your constitutional court. And thereafter, we have the other courts that fall below that, which the second court under your constitutional court should be your Supreme Court of Appeal. Then you move to your high courts, and then you move to your magistrates' courts below, right? So the short process courts we also have, and we have the small claims courts. Now, the small claim court will resolve your disputes involving your much more smaller monetary sums itself. And sometimes parties prefer the small claims court because, remember, this is a far faster process in some instances, and also you do not require the services of an attorney to actually appear in the small claims court, which is why sometimes it's a better process for parties because it can afford you to save money. Then we have our African indigenous courts, and this deals specifically with indigenous issues that come before the courts itself. Magistrates Court, High Court, and our Supreme Court of Appeal is what we're going to be dealing with in the following slides hereafter. But remember as well, Mantua mentioned earlier that specific courts will deal with specific issues. So the Constitutional Court now is only going to be dealing with constitutional matters, right? And when it comes to constitutional matters, your Constitutional Court is your highest authority in this regard.
Okay, so now we're going to start with the inferior courts, right? So our inferior courts are our lower courts in the hierarchy. So we have the small claims court, the short process courts, the chief and headman's court, which is your indigenous courts, like Cindy just mentioned, and then we have your magistrate courts. Important here when we're talking about judicial precedent and the principle of stare decisis that we spoke about in study unit 1. These courts do not create precedent. Very important. They follow the precedent by the higher courts. So important points, they cannot create precedent. They cover a small geographical area. And what do I mean by this? Think about it. We're in Durban. We have the Umlazi Magistrate Court. We also have the Durban one. And all the different areas in and around Durban have their own magistrate court. All right? They also handle less serious matters, and we'll go into those serious matters. You need to know for test purposes exactly what matter the courts can handle.
Right. So the first court that we're going to look at is the short process court. Now, the purpose of this particular court is to minimize the issues in dispute. In other words, minimize the types of aspects that are coming forward to the court on a particular matter itself. And you can look at more on this at page 21.
Yes, please go to page 21. There is detailed information on the short process court. You have to take that, you need to summarize it yourself and give us feedback on it model based on the information that you get there. Small claims court, very important here. No lawyers, like Cindy said, very informal, the cheaper option, because if you have to pay for an attorney and advocate to represent you, it's going to cost you a lot more. So very informal, no lawyers. You represent or you present yourself. No litigants are allowed, only natural persons are allowed. And I'm going to explain that in detail just now. The maximum you can claim here is 15,000 Rand, right? And it's only for civil matters and the same type of matters that the district court, which is higher than the small claims court, the same type of matters that the district court can hear. Go to page 21 to get more information on that. As we've mentioned already, it's easily accessible because it's cheaper, all right? And anybody can walk into the court, fill in a form, and speak to them about their disputes. What's important as well is to know the presiding officer for each court, all right? The presiding officer, the judicial officer for the small claims court is the commissioner. Do the same for the short process court. Important here, only natural persons can approach a small claims court for a dispute. It doesn't mean that the defendant cannot be a juristic person. What am I trying to say here? The plaintiff always has to be a natural person. In other words, a company cannot approach the small claims court if they have a dispute. Natural person approaches and the defendant happens to be a natural or juristic person, that's fine. But this is not a place where a juristic person can go and get a remedy as a plaintiff.
Now we move on to the next court. So the bottom level we did was our small process court, and then we did the small claims court, and now we're moving on to the magistrate's court. Remember, it's that hierarchical unit aspect we were talking about. So as you can see, we're climbing up the hierarchy with the courts now. So the magistrate's court now is what we refer to two types of court that fall under this. The first one is the regional magistrate's court and the district magistrate's court. Now the difference between these two types of courts is in terms of their jurisdiction, which means the types of matters they can hear, the geographical area itself, and importantly, the maximum fine that can be imposed by these particular courts and sentence as well. Because that would be different for a district court and it would be different for a regional court. Now, in your district magistrate's court as well, it's important to remember that this court deals with more your minor, petty type of offences, right? So like theft of, say, property to the value of 200 Rand, a shoplifting type of matter. Those are the types of cases that would be heard in the district court. Whereas once the matter gets more serious, then it will proceed up to a regional magistrate's court level. And of course, if the state is trying to secure a higher fine or a higher penalty, then in those instances, they would make a decision and not opt for the district court, but rather approach the regional magistrate's court itself. Now, in these type of courts, you take from the name itself when you're looking at the judicial officers that's involved. Like the name says, magistrate's court. So in other words, your judicial officer in this instance is going to be your magistrates. And in some types of matters, sometimes we have what is called an assessor who gets involved in a particular matter and assists the magistrates in coming to a decision. Now remember, the important difference between these two is that the assessor does not make the decision. The judgment is still made by the magistrate itself. But the assessor will perhaps guide the magistrate. Perhaps it's some type of community matter involving maybe multi-murders. So in those instances, the assessor would be somebody who have experience and skill and knowledge in this regard and would just give the magistrate pertinent information which would then help the magistrate to make a decision in that regard.
All right, so now we're going to zoom into the district court. So just like Cindy mentioned, we have the magistrate court is split into two. The inferior magistrate court is your district court, and that's where we are. And the superior one is the regional court. So in this court, it has jurisdiction only over the specific district. So if it's Durban, it's that specific district. Here, both civil and criminal matters. Go to page 19 because this is important for you to know exactly what civil and criminal matters you have there. For civil cases, please, this is the part where I'm breaking down exactly what civil cases the district court cannot hear. So if this is in a scenario, automatically you know that the district court cannot hear this case. So the exclusions in civil cases are as follows: divorces, adoptions, sanity. What do I mean by that? If you want to get an order of court to prove or to state that somebody is insane and can't manage their own affairs, you cannot go to the district court. The same way around, prove that someone who was previously certified as insane and now you want to certify them sane, district court is not your court. Validity or the interpretation of a will. So if you have a will, remember we did law of succession in Unit 1. If you want to validate the will, this is not the court for you. The granting of a perpetual silence or an order for specific performance without an alternative claim for damages, this is not the court for you. The monetary limit, and this is important, the monetary limit in this court is 200,000. Cindy just gave you a brilliant example. She said you would go here for cases like shoplifting. You're not going to shoplift something worth 200,000. So for your minor type of cases, you need to look at the monetary claim, which is important, and you also need to look at the type of offense.
All right, so continuing now with district courts, we look at the sentencing and what we refer to as correctional supervision. Now, sentencing involves different types of aspects. It could be indirect imprisonment, it could be a suspended sentence, or it could be a fine, right? And in some instances, the court also makes an order for correctional supervision. Correctional supervision is, you serve a period of time and you will be out of the prison system itself, but you've got to report to the police station maybe once a week or every day, depending on the type of sentence that's imposed to you. Now, with district courts, this type of sentencing and judgment is actually limited to a maximum of 3 years. So if the district court can make an order for 1 year, 2 years, and up to 3 years, not beyond that, right? The fine that can be imposed is not more than 120,000 rand. So the district courts can make an order for 50,000, 100,000 even, but not exceeding 120. Now, important for you to remember this as well, that earlier I mentioned that the district courts deals with minor petty types of offences, right? But it's important for you to remember that there are 3 types of matters that is completely excluded from the jurisdiction of district courts, and that is murder, rape, and treason, because these are the category of offences that's actually considered to be more serious. So they will be heard by the higher courts.
All right, now we're going to the higher magistrate court. Emphasis again, none of these courts create precedent. So if a decision is made here, it doesn't have to be followed by the district magistrate court, all those small claims court, because it does not create precedent, as much as it is the highest magistrate court. So the regional magistrate court has jurisdiction only within that specific region. Again, it hears both civil and criminal cases, and here the monetary limit is 400,000. If it's higher, then you have to go to a higher court to hear that specific matter. So the exclusions here is everything except for treason, so they can hear any matter, any civil matter. In your criminal matter, treason is excluded. And I want you to go and conduct some research regarding what treason is. What type of crime is that? You need to be able to identify it. The sentencing limit here is 15 years for each charge or for each crime. And the fine must not be more than 600,000. Please be careful in a test or an exam. Look at what we're trying to impose. Are we trying to issue a fine, or are we trying to claim a specific monetary amount? When you're trying to claim, your limit is 400,000. In terms of the court imposing a fine, it goes up to 600,000. So please get those details correct.
Now,